Good day, ladies and gentlemen. This is Dr. Frel, your professor.
Hello class, good morning. Our topic is regarding the procedural requirements in the termination of employment. For our objectives, we have two. First is to determine the different methods for termination of employment, and the second is to explain the procedural requirements in the termination of employment. Now let's define first what is termination. Termination is defined as the separation of the employee from the organization, or it is the process used by firms when they close facilities, when they reduce workforce, or when they respond to continued poor performance of employees or the entire organization. My question, class, now is when do we need to fire an employee? That is, if we have taken the necessary steps to help the employee improve his work performance and yet they are not working, then that may be the time for us to terminate the employee. Now, under the 1987 Philippine Constitution, on Article 3, Section 1, it provides that no person shall be deprived of life, of liberty, or property without due process of law. So the same applies in the termination of employees, particularly on that phrase, due process of law. So there are twofold issues of due process. We have the substantive and the procedural. When we say substantive, these are those valid and authorized causes of employment termination as provided under the Labor Code of the Philippines. When we say procedural due process, these are the manner of dismissal before an employee is dismissed, that he must first be given an opportunity to explain his side and of course be heard. So again, class, due process now in the context of employment termination is the right of an employee to be notified of the reason of his or her dismissal, and in the case of just causes is for him to be provided the opportunity to defend himself or herself. So in this context, class, due process is different from both the authorized and just causes. So again, what is the substantive due process? So this essentially refers to the causes or the grounds for termination. And generally, it includes serious misconduct, willful disobedience, gross and habitual neglect of duty, fraud, loss of trust and confidence, commission of a crime, and some other analogous cases. So remember, class, that this substantive due process is based on the premise that the Constitution protects the public from unwarranted government intrusion, infringing upon their fundamental rights. So, if the government passes a law that infringes on life, liberty, and property rights, a substantive due process analysis must be performed. Now, how about the procedural due process? According to Article 285 of the Labor Code, employees in the Philippines can quit their jobs either with or without a just cause. So without a just cause, your employee needs to hand in a letter of resignation with a 1-month notice. If we do not submit a notification, you can charge them for any concurrent damages. So again, class, for just causes of termination, procedural due process requires 2 written notices and an ample opportunity for the employee to be heard. Okay, so now class, we have the due process for just causes again. So this just cause procedures refers to the steps or the process of implementing due process in relation to termination of employment. And there are three steps in a just cause procedure. The first step is the issuance of the first written notice. So in the written notice, it should include the ground for or the violation for the termination. And of course, the employee is given 5 days to have that opportunity to study the accusation against him. And of course, for him to gather data or to consult the union if they have, or a lawyer as the case may be. And the second step is the observance of the ample opportunity to explain by the employee. Then, of course, the hearing or the conference. No? So this is where the concerned employee is given the opportunity to respond to the charge or charges against him. So he will present his evidence of rebut or against the evidence presented or charged against him. But of course, this does not require a trial. This is but is sort of or a type of formal hearing, no? So to be heard in this case does not mean verbal argumentation. This might be in the form of written explanations or submission of pleadings. Then next, the third process is the written notice of termination. So in this written notice, all circumstances involving the charge against the employee have to be considered, as well as the grounds that had been established to justify why the employment of the employee is to be severed. So class, this notice of termination is the official document which is being made by an employer that is issued to notify an employee that their employment contract has been terminated. Then how about this preventive suspension? This preventive suspension is a disciplinary measure for the protection of the company's property pending investigation of an alleged malfeasance or misfeasance committed by the employee. So the employer may place the worker concerned under preventive suspension if his continued employment poses a serious and imminent threat to the life or property of the employer or of his co-workers. So this preventive suspension should not last 30 days, and after that, the employee should be reinstated. Now, the question class is, can an employer extend the period of preventive suspension? The answer is, of course, yes, provided the employee's wages and benefits are paid in the interim. In that class, no, preventive suspension is necessary for, of course, for the protection of the company and its operations pending the investigation, as what I have mentioned earlier. Now, class, in a termination for an authorized cause, due process means a written notice of dismissal to the employee specifying the grounds at least 30 days before the date of termination. Now, such notice should be given individually to the employee, and in cases where the removal of the employee is questioned, then a hearing could be considered. So again, class, just be reminded, no, the difference between these just causes and authorized causes. No, when we say just causes, again, they are based on acts which are attributable, no, to an employee's own wrongful actions or negligence. No, while authorized cause or causes refers to lawful grounds for termination which do not arise from fault or negligence of the employee. So now my question, class, is what if the employer failed to observe the procedures required for the termination? or will it render the termination illegal, or will the same valid? So in answer to that, class, be reminded of Article 282 of the Labor Code that provides that an employer can terminate an employee for just causes, which could be any of the following: commission of a crime or offense by the employee against the person of his employer or any immediate member of his family or his duly authorized representatives. Now we have some critical factors to consider in terminating an employee. We have first, you have fight or flight. So with this factor, how you have to look into how the problem employee will take advantage of you. Will he fight or will he leave? Second factor is your problem employee will destroy your morale and results. So consider if you do not do something about it today, then that problem employee might do some destructive acts against the morale of the company or the results. Then the third is the longer you wait, the longer we wait. So that might result to the more it is hard for us to terminate the problem employee. Okay, now I have here some doses of terminating employee. The first is you have to make the firing decision carefully, but once made, you have to implement it quickly. You have to act quickly. The second is you have to ensure that multiple meetings have been held with the employee. That is in order to determine or to hear his side and to determine if the charge against the employee is reasonable. Then another is be respectful, of course, and be discreet with the processes. Then fourth is you have to ensure that your severance or notice arrangement meet legal requirements. Yes, that's right. You have to be careful with the legal requirements of the termination. And the fifth one is to ensure that you have a written termination letter and release it, documents the terms and the conditions of the termination. Now, how about the don'ts or things to be avoided in terminating employee? First is don't get personal. So the grounds in terminating the employee should be based on or it must be related, or in deciding for the termination of the employee should not be biased or prejudice, should not be made personal. The second is don't make a decision to terminate for cause without conducting a proper investigation. Yes, as mentioned in the dose of terminating employee, you have to have some meetings or hearings if necessary in order to conduct a proper investigation of the charges. Then the third is don't hold the termination meeting in a public place. Yes, that is a big no. You have to you have to keep it as private as possible to give or to protect your employee and the company as well. Then the fourth one is don't go into a termination meeting unprepared. Yes, that's another. You have to be prepared with all the necessary documents so that once asked, you have your reasons, you have your evidences to back up with your claims. And the fifth one is don't get defensive or debate the merits of the firing decision with the employee. Okay, you don't have to be defensive. Why? You have that decision. Because decisions to be made shall be based on the merit of the charges in the documents that are being presented. Okay, class, so that would be all for this topic and for your activity. Please create a group of 5 members, and out of that 5 members, you have to prepare a 3-minute video of a situation of an employee terminated from work. Consider the principles discussed in this topic. Submit your output in the Google Classroom. So again, class, thank you for watching. See you in the next video.